The 261st District Court is back in session.
Okay, so I can't say that I got through all of these documents, but I am ready to hear some argument before we continue with Mr. Machuco's testimony. So I think on the first issue, Ms. Burgess, I'll start with you. It's your motion for reconsideration, I guess.
Right, Judge. So you, because of the testimony, ruled that we could not question Mr. Machuca about his understanding of the documents that were taken, the ranking spreadsheets that were taken off of our Google Suite, and that Mr. Saylor has had a chance to continue, that he's continued to use. Nonetheless, the defendants heartily have cross-examined him on those issues, and we would like to be able to have Mr. Machuca testify about what those are for Flow Sports, so that so that it goes both ways. He can't just be crossed on it and not directed on it. But I don't know if you had a chance to read the brief that we filed.
Yeah, a lot of it has to do with what's a trade secret and what's not is sort of the last half of it. So I'm not sure that helps us solve this problem. But let me remind everybody that you know, when Mr. Brudical was asking his questions on Friday, the situation was as it was at that time. Since then, when Mr. Soltero asked a question, as I said on Friday, if they open a door, then your client gets to walk through it. So if they start opening doors, then we are in a different new kind of situation. I don't know whether that's happened or not happened. I'm not going to say about that at the moment, but keep in mind, if the defense starts opening doors, the plaintiff gets to walk through it and vice versa. So despite whatever ruling I may have made on a particular question on Friday, that answer today might be different because something may have changed in the universe since then. That is, someone else may have asked a question that they were allowed to answer, and so you get another bite at that apple, perhaps. That may be what we're dealing with, maybe not, I don't know.
And Judge, that's what, I'm sorry.
So that's one issue. Obviously, on redirect, if Mr. Soltero or Mr. Brudical has asked some other question that your client gets to, and they insist on an answer, and I let him answer it, then you get to follow up on those same topics.
Well, and that's where we are right now. We have, so what happened was kind of in a strange, the impeachment process has been odd to say the least in this case, but but in a strange impeachment in camera, Mr. Soltero showed you a clip from the deposition, and you said, I said, I need to explain what the timeline is. And you said, I'll give you a chance to ask for reconsideration of that. And you also mentioned the opening the door issue. And so what we've done in the brief is that first we've clipped in the question that was the subject of the objection to foundation. Mr. Soltero said that our client had no foundation to talk about the rankings. And then we go through and we explain that, well, I mean, you know, the compilations of data like rankings, like these spreadsheets can be trade secrets. But what we explain at page 3 is the actual prior testimony. He was asked if he had seen the rankings spreadsheets. He said yes. And then he says that, but then when he's asked a different question, he's asked, did he take those off the Flow Sports laptop, which was one of the initial issues way back a year ago. But then as we went through the year, it wasn't until September 16th, 2020, the night before the hearing that we had on discovery before you, that we ever got those rankings from Mr. Saylor. Mr. Saylor now freely admits, and this is all at page 5 of his deposition, that he took them, that he uses them, and that he continues to access them, and he's done that since he left. So this is a really important issue because rankings is Mr. Saylor's bread and butter, and rankings is what Rockfin wanted. And what happened was Saylor took these with him so he could get up and running right away. In fact, in the opening, you might have seen there was a slide that showed a camera. He was taking pictures of the studio equipment so that Rockfin could buy him new studio equipment. And he was taking pictures of it, and open on his screen were all of these spreadsheets. I bet you have to blow up the picture to be able to see that. So he was referencing them and using them from day one. In fact, I don't know that there would have been a carve out in the temporary injunction had he admitted that he was taking with him data from Flow Sports on this topic. In fact, and Mr. Saylor.
Here's part of my difficulty though. One is that so much of this it feels just premature. When it's your turn to redirect, let's cross this bridge when we get to it. We may or may not have an objection. I don't know that I need to reconsider anything at this point because you still have another bite at the apple. So
that's fine. And
let's digest it when we get to it, because at the moment I just don't see it as a ripe problem. You don't get to make a closing argument in the middle of their cross-examination. You don't get to, decide. I mean, I feel like you still have an opportunity. And so I don't feel like I need to go back and reconsider something from Friday. I think I need to consider it fresh when we get to it today, if we get to it today, because it may or may not be a problem. So I just keep wanting to move forward, not go backwards. And I feel like we're spending a lot of time kind of going backwards. So the rule still stands. If somebody opens a door, the other side gets to walk through it. So to the extent that you feel like they've opened that door, walk through it, and we'll see if there's a problem. We'll see when we get to it if there's a problem or not. That's kind of how I'm feeling about it. And so I'll just leave on the table for now your motion for reconsideration, which I've not completely digested anyway in the short time we had at the break. And so in fairness to you and Mr. Soltero and Mr. Rudicow, should they decide they want to respond to it in writing, they can. But I don't know that I need to worry about it right at the moment because you still have a chance to redirect. So let's kind of move on that point. And then I double check. Yes.
I think that the problem here is that they're about to play a clip of the deposition that's not representative of what actually happened, because they just want to show it to the internet. So it's,
I don't know that they need to, I don't know what they're about to do, but as I say, when they get to it, make your objection at that time and we'll see. If it was in his deposition, it was in his deposition. I don't know showing it is going to mean anything one way or the other. And once again, you get to redirect. So I'm not sure that it's that big. I mean, frankly, I'm just not sure that it's something we should worry about at the moment. Everything that's happening in this trial just about is happening on the internet. So, I mean, their spin happens on streaming and your spin happens on streaming. I mean, I don't know that we can avoid that.
I understand. I do want to make sure that we get the optional completeness in though, and we will ask for that at the time when it comes up.
Yes, and I hope you've had a chance to review that and confer with counsel, because obviously when they offer something, if it's under the rule, you get to offer it right at simultaneously or contemporaneously. So no problem with that. I think those are the two things. And since it's a little after 1, let's get back on.
Your Honor, may I be heard for a second? Number one, I think I just want to be clear that I completely disagree with Ms. Burgess's characterization of the testimony of Mr. Saylor and some of these other things. But put that aside, what I wanted to be clear about is we didn't fully confer, because I gave her the clip that I was going to use for impeachment, but nobody ever told me what they consider to be optional completeness for me to be able to look at and say it is or it isn't optional completeness. I don't think that it is.
Let's get that figured out. What do you?
It's actually 2 issues on the optional completeness. Was that on Nittany Lions or the ranking spreadsheets? Nittany Lions. On Nittany Lions. So on Nittany Lions.
No. Wait. I mean, Judge, I don't know what she's trying to get into, but there are things about, I'm going to pass on the spreadsheets because I heard Your Honor loud and clear. I'm not going to try to open a door that I think has been closed. I don't know what she's talking about with Nittany Lions, but I wasn't asking about Nittany Lions. I was asking about what they knew about Willie Saylor and live events.
And Judge, this was not a topic for the corporate representative depot in the first place. We are not, they might say damages was, but it wasn't, we're not asking for damages on the live events, only injunctive relief. He talked about Willie Saylor's involvement in the Nittany Lions wrestling.
He didn't talk about that when we said we needed to have you confer on optional completeness, though. At that point this afternoon, he was asking about live events that Flow Sports lost, if any, because of Mr. Saylor.
And that was not a corporate representative topic, first of all. And second of all, the way that the timeline works doesn't make sense for that to be impeachment, because his deposition was taken on September 21st. The event happened on the 19th. And then on the 2nd, we got Saylor's supplemental document production that showed the text messages between him and Cale Sanderson, where he's directly involved. And then Saylor admitted to that in his deposition on October 5th. And there's no duty to supplement deposition testimony, especially on a topic that wasn't even designated. So it's not.
I'm confused by what you're saying.
Okay, so
No, let me tell you why I'm confused, and then you can help me understand it better. I am confused because if there is nothing for Mr. Soltero to show us, then there can be nothing else that would complete that topic. So if there's nothing in the deposition that he shows us on which you claim that there's more to show us under the rule of optional completeness, then I don't understand what you're saying.
well, there absolutely is more to show us, and I'm sorry.
Okay, well, let's stop. So if there is, that's great. Tell them what it is. Give them a page number and a line number. They can review it, and then we'll have context for whether it's optional or not, or whether it's complete or not. And then they can react to whether it adds to make it complete or not. But at the moment, on the issue of no live events, that's the issue on which he wanted to show something which you said you wanted an opportunity to complete under the rule of optional completeness. So we know what Mr. Soltero wants to show. What do you want to show?
Well, Katie, could you show the screen?
No.
Tell us, just tell me page and line from what you want to show.
34 lines 1 through 20, particularly lines 1 through 6, where he says, "I'm not prepared for this."
No, don't repeat it, Ms. Burgess. Just give us page and line number.
Great. 34 1 through, is it just 1 through 6 or 1 through 20? 1 through 6. 1 through 6, and 187 24 through 17, or 187 24 through 180. Is that 186?
Sorry, it's 186 24 through 187 17.
Okay, all right, Mr. Soltero, Ms. Brutico, you can take a look at that and tell me whether or not you think that that's related to the same subject or not.
Your Honor, I don't think that page 186 is related at all, because it has to do with Rockfin, not my client, Willie Saylor, which is what the question I was asking was about. The one on page 38 has to do with the corporate
Not
representative.
page 38, page 34, 1 through 6, as I understood it. Did I get that wrong? I heard 34, 1 through 6.
Yes, so 34, that's fine, Judge. If they want to play that, that's no problem, or read it, no problem. But
Okay.
the other one has to do with Rockfin, not Willie Saylor.
Well,
Ms.
the answer
Burgess?
deals with Willie Saylor. The answer deals with Willie Saylor. It says the fact that
It
Rockfin,
doesn't say Willie Saylor at all.
it
like the
does.
Rock-
Look at 7 through 10.
Okay. Well, I don't think it is optional completeness, but I mean, I don't know how Your Honor can rule without considering it doesn't, let me play my part. They want to do optional completeness. Let them do whatever they want to do.
Okay, Mr. Brutico, anything to add to that?
Yeah, I don't think that 186, adds optional completeness, does not complete what Mr. Soltero was reading, wanted to read into the record.
Okay, is Mr. Saylor's name mentioned in 186 and 187, 186, 24 to 187, 17?
Yes, Your Honor, I saw it is. I didn't see it initially, but it is mentioned one time.
Okay,
Yes.
well, I'll let her play it. If she thinks it completes it, that's fine. I can't evaluate it without looking at it, and I don't know that it seems pointless to look at it twice. So if she thinks it completes it, fine. I'm ultimately going to be the fact finder. I'll decide. So let's just hear it. I got to look at it anyway. Might as well hear it once. All right, that's more efficient in my mind. All right, let's get Mr. Machuco back in here and let's finish him up.
Judge, I have basically 2 areas of questioning only, just for time and getting everybody the heads up.
Okay.
Okay. Mr. Weisbrot, if you could play impeachment video 3, which is page 35, line 10 through 14.
So you're gonna play a video and then I'm gonna do optional completeness and then you do this to read. One through 20. Do you have page 34?
Mhm.
Okay. Can I have it? Thanks.
All right, Mr. Machuco's back, and so, sir, is just a reminder, he's still under oath, and Mr. Saltero has the floor.
Thank you, Your Honor. Mr. Weisbrot, if you could play the impeachment clip.
Wait, I'm sorry, just to be clear, because I think what's on the screen is not the page 34 that I thought we were gonna hear from, so are we looking at the right?
It is the right one, Judge. It's page 35, line 10 through 14. Exactly what I asked him before Ms. Burgess interjected with wanting optional completeness.
Okay, I was expecting page 34. I just want to make sure the record is clear that the clip you're now showing is page 35, lines 10 through 14. Is that right?
Yes, Your Honor.
All right, very good. Go ahead.
Asking for something slightly different, which is, as a factual matter, there have been no live events that Flow Sports has lost because of Willie Saylor, correct?
Correct.
That concludes the impeachment on that portion.
I'd like to offer optional completeness, Your Honor.
Okay, go ahead.
Okay, first is lines, page 34, lines 1 through 20, is that right here? Yeah, I mean 1 through 6, I'm sorry.
Yeah.
Lines 1 through 6, which is, he was asked, Mr. Soltero says, you can find that funny, but it's true. I'm asking you to truthfully answer under oath. Does Flow Sports take the position that anything Willie Saylor did caused it to lose any rights to live events? If the answer is no, but I'm trying to see if you have a different answer. And he said, again, I haven't prepared for this question. And then seeing as how it wasn't a topic. And then now I'm going to read from 186 through 187.
All right, Ms. Burgess, seeing as how it wasn't a topic, sounds like
Yeah,
it was
that is
coming
not.
from you.
That was from me. Yes. Sorry
Yeah.
about that.
Oh, don't do that, please.
Okay, I won't
Stop
do that.
making
Okay.
sidebar comments because it messes up our record and is very confusing. So just quote and then stop quoting and then tell us when you get to the next page in line, please.
And Your Honor, if I may intercede, I have optional completeness to that, given what she's read, because the very next line is, well, isn't one of the topics that on the corporate rep notice the damages? And he said, yes.
And we're not asking for damages for the live events. So it's.
And this is not closing argument, ladies and gentlemen. Stick to optional completeness. I want a page number. I want a line number. I want you to stop and start at a quote that is directly from the document and nothing else. I don't want any argument. I don't want any sidebars. I want to get through this efficiently if that's possible. Can we agree that that's how we're going to proceed?
Yes, Your Honor.
Yes, sir.
All righty.
So
Next
may I
page,
continue?
Ms. Burgess.
Yes, this starts at page 186, line 24 through page 187, line 10. And it is question. And what is the basis for your testimony that it is a Rockfin produced event as opposed to a channel creators event? Answer, ask again. Question. Well, okay, you said something that just happened this weekend, right? Answer, uh-huh. Question, what are you referring to? Answer, the fact that Rockfin is putting on live events in the wrestling space and Willie is doing everything he can to promote these events and furtherance of, to promote those events and furtherance of the events. And that's the end, that's at line 10.
All right, very good. Mr. Soltero, you may proceed.
Thank you. Mr. Machuca, isn't it true that you frequently told Mr. Piles that he should fire Mr. Saylor?
I wouldn't agree to that characterization, Carlos. Mr.
Well,
Soltero, sorry.
It's true that you told Mr. Piles on more than one occasion that that you thought that he needed to fire him.
Again, Mr. Soltero, in all those contexts, I would counsel Christian to do one of the following. You have to either figure it out or let him go.
Mr. Machuca, do you remember that when we took your deposition on September 21st, 2020, we talked about this very issue? And in that, on page 75, line 8 through 9, and going on to page 25 of that page, but I'm just going to start with the top and share. Okay. Mr. Machuca, do you have it there in front of you in addition to the screen?
No, sir, but I see it on the screen.
Okay. You testified, did you not? I don't think he's forthright. I don't think he's honest. I think you need to fire him. You said that because that's what you told Mr. Piles previously, right? Yes or no?
Well, hold on, Mr. Soltero. I thought you just asked me broadly, isn't it true that you had told him many times that he needs to be fired? And I was just trying to clear the record that I said many times, I would say that complete sentence, like that complete statement. You either need to figure it out or let him go. In this instance, the one instance you're talking about, yes, I did say this. But in the previous question, you asked me, isn't it true you have been saying this for a while? I just wanted to clarify. I've also said you need to work it out or let him go.
But Mr. Machuca, the very next question, you said this happened on multiple occasions, did you not?
Yes, it also happened on multiple occasions that I said you need to work it out with the guy.
And then he would improve, but then he would backslide, right?
That's right.
Okay. So then finally I asked, so tell me about the multiple occasions this happened. When was the most recent one? Did it happen in 2019 more than once? And you said, yeah, you know, when this sort of thing with Willie would happen kind of frequently. And you know, I'm not in the habit of documenting every time, Carlos. I'm not trying to be evasive. I know, you know, yeah, I'm sorry, etc. Was that your testimony in the deposition?
Yes.
Okay, so on more than one occasion, you told Mr. Piles, who was Mr. Saylor's direct supervisor, that he should fire him.
Given the choice of two things, you either have to do this or do this. Yes.
Was the answer to my question yes?
Yes.
Okay, I'll pass the witness, Your Honor.
Okay, so can you help me with some, the spreadsheet? Yeah, I just pulled up the spreadsheet. And while you're doing all this. Okay, Mr. Machuca, you've been here for a while. You saw on cross-examination, you saw some internal email at Flow Sports about Willie Saylor's exit. Did you?
Yes.
At that point, did you know that Martin Floriani had been recruiting Willie Saylor to Rockland for 9 months?
Objection leading and assumes facts not in evidence.
Dane?
Now, you were asked about Mr. Saylor being upset in 2019 and these conversations you had. Can you tell the court about conversations you had with Mr. Piles and Mr. Saylor over time?
Sorry, do you mean about his performance? I mean, conversations
Right, yes.
time seems a little broad. Do you mean about Mr. Saylor's performance?
About Mr. Saylor's performance over time and when issues started.
Yeah, I think that, so Willie's a very passionate, Mr. Saylor's a character, very passionate. Like most content creators, they are prone to ups and downs. Having run-ins and disagreements was not something that was one-off occasions or occasions where we want to fire somebody. It was ongoing stuff with Willie. In fact, Because actually, those disagreements and headbutting was actually a really good thing about Flow Sports. We welcome disagreements, so that was just par for the course for me and Willie Saylor's performance with Christian Powell's.
And did that change in 2019?
No,
Now, let's go to Mr. Weiss. Right, if we could go to 160, exhibit 160, F-160. And in particular to page 3. So if you could pop out 3B. You were asked questions, you recall being asked questions about the sports video industry?
yes.
Okay, and is there any reference to the sports video industry or the business of the company or competitor in section 1?
Compete with the company in region.
Objection, document speaks for itself.
He was thoroughly questioned on this document and asked about Flow Sports intent around it.
The objection's overruled. You can answer the question if you see anything in there.
I missed the question, Karen. I'm sorry.
Sure. Is there anything in the first section that references the business of the company, sports video industry, or competitor?
No,
In the second section, does it say that you can't compete in the sports video industry?
no.
What is the prohibition?
You can't participate in ownership, management, operation, financing, control of any person, corporation, firm, or entity that is
yeah,
engaged in the business of the company.
Okay. And in the last one, does it say you can't participate in the sports video industry?
No.
What is the limitation?
You can't perform same or similar duties.
So it's just same or similar duties.
Correct.
Is Mr. Saylor doing same or similar duties at Rockfin?
Yes.
And we went through a chart about that, I think.
Yes.
Now, why are ranking spreadsheets so proprietary in this case?
Objection, Your Honor, that's compound. Rankings and spreadsheets are two different things.
That's right. I'm talking about the ranking spreadsheets.
Objection vague.
Okay, I can ask 2 different questions.
When you all are ready for me to make a decision, just let me know. And when you're stopped chatting with each other, I'm happy to chime in. You know, I kind of like that part of my job, but you know, it's okay. I can be patient and not do that part of my job for the next few minutes if you guys just want to chit chat. Ms. Burgess has the floor.
Mr. Machuca, I'm going to ask you about 2 different things. First of all, rankings and then ranking spreadsheets, okay?
Okay.
Okay, tell me what Willie Saylor did with regard to rankings on Flow Sports and Rockfin.
So Willie was Mr. Saylor's core competency was creating rankings and ranking sets and analysis off those rankings and content around those rankings. That's his expertise, and that's what he's really good at. That's what he did for us, and that's what he's doing for Rockfin.
And at some point, did he remove rankings from Flow Sports?
Yes, he did.
Objection leading.
When you say
Dane,
when you say he removed rankings from Flow Sports, what happened to the rankings? What was the process?
The process is get into the CMS or the content management system. You can delete them. You can mess with the date so they disappear. And then that's it. They were deleted or removed. And then they appeared on Rockfin.
Is that how you found out that Mr. Saylor had left?
Objection leading.
sustained.
No, I found out
Excuse me,
he
Could I ask, excuse me, that's objection was sustained, which means she's going to ask you another question. You're not going to answer that one. Ms. Burgess?
Sure. How did you find out that Mr. Saylor had gone to Rockfin?
I walked in the door. I walked into our office Monday morning, and a member of the content team walked up to me and said that our rankings had been deleted, and the rankings were now on Rockfin.
And did you observe that yourself?
Yes, I was shown someone's laptop with it on there. Yes.
And did those get returned at some point?
Yes.
Now let's talk about ranking spreadsheets. So when you're talking about the rankings that you just said, are those outward facing or are those inside the company?
The rankings that we're talking about that were on the websites, those are outward facing. Those are the end result of the other work.
Okay, and are there compilations of data about wrestling that are kept in spreadsheets?
Yes.
And is that how Mr. Saylor kept his spreadsheets at Flow Sports?
Objection leading.
Sustained.
How did Mr. Saylor keep up with all this information so that he could generate the outward facing rankings?
Objection, foundation, lack of knowledge.
He may have it, but he's not clear to us how he would know. So perhaps you could lay that foundation.
Mr. Machuca, do you know how Mr. Saylor, both personally and as a corporate representative, how Mr. Saylor kept his rankings data?
Yes.
Okay, and how did he keep it?
In spreadsheets, in his G Suite, on Google Sheets.
And did Flow Sports pay him to do that work?
Yes.
Object,
Sorry, Your Honor.
How
No, it's
many
okay. You didn't do anything wrong. Go ahead. Is there an objection?
no, Your Honor.
Go ahead.
How many years did you pay Mr. Saylor to create these databases or spreadsheets?
8 years?
And what else did you pay for in order to gather the data for that?
I guess probably the biggest thing is, so part of the reason why I know is that Mr. Saylor's whole job was to sit in a chair, watch wrestling, go to wrestling events, report on, provide general coverage for, speak to wrestlers, wrestlers' coaches, wrestlers' parents, and accumulate data so that he just became the biggest and loudest and most prominent and most galvanizing, strongest voice when it came to this content type in the world, in wrestling, period. And so the reason why it's so valuable is because if you just look at any spreadsheet, this is what I did, you look at any tab on any spreadsheet, every tab will have hundreds and hundreds of data points. And there's tens and tens and tens of spreadsheets. And so, you know, it's thousands of data points. And if it's, you can't keep it in your head, it's your body of work. You want to take it with you, but it's not yours to take, it's ours.
And have you had a chance to look at the spreadsheets that Mr. Saylor produced back to us?
I did.
And do those contain the same information as the ones on the Google Suite from Flow Sports?
Objection, Your Honor.
Foundation.
This is the door they
Hang on.
walked through.
I'm hearing things in stereo. What's the objection?
Mr. Soltero, go ahead.
The objection is lack of foundation, and he wants to talk about now about things that he saw in the course of the litigation that he has no personal knowledge of.
And I added leading as well, Your Honor.
And it's a prior issue that we had yesterday, Judge, that Your Honor sustained and denied without prejudice during our hearing on the reconsideration.
And
So-
that's where, I'm sorry, go ahead.
So first of all, the leading objection is sustained. That alone will require a new question. Ms. Burgess, you've done that several times now, and I've sustained several objections to leading. So try to open them up so as not to have that problem, and that may solve many of our problems. So let's start with that.
Has Flow Sports made a contention about the ranking spreadsheets,
Yes,
and what is that contention?
that we paid Mr. Saylor to accumulate and hold that data, compile that data, and then he is taking it with him and he's using it now for a competitor, and he's admitted to using it for a competitor.
And would that give a competitor like Rockfin a head start?
Objection leading.
Sustained.
Tell me how that would give a head start.
They are able to short circuit 8 years of investment. They're able to stand on the shoulder of that work without having paid for or earned that work themselves.
Now, have you had a chance to look at what Mr. Saylor sent back?
Yes,
And could you tell the court about whether that supports your contention?
Objection, foundation.
I'm sorry, I didn't understand the last part. It trailed off. Whether that supports was all the last I heard.
that contention. He was crossed vigorously on the contention about the rankings.
No, I just needed you to repeat the word. I didn't hear what you said. So let me make
Oh,
sure the
sorry.
question was, could you tell the court about whether that supports your contention? Is that what you said?
Right.
So, and by
Yes.
your, you mean Flow Sports?
I mean, flow sports, yes.
Okay. And what's the objection?
Objection, foundation, and it circumvents the ruling that Your Honor made on Thursday.
I don't know that that's correct. I'm going to overrule that objection. Whether or not he believes that this supports Flow Sports contention is a question he can answer. Doesn't mean it does, just means he thinks it does or doesn't. Mr. Machuco, you can answer that question.
The reason why it supports my
No,
contention,
no,
Your
that's
Honor.
not the question. Does it support was the question, not
Yes.
why.
Sorry, Your Honor. Yes.
And I would then ask why.
Okay, objection, this goes to the ruling that Your Honor made that Mr. Machuca testified in his corporate rep deposition that he was not aware of these spreadsheets being misappropriated or exported.
So herein lies the problem that we dealt with, and which I have to confess that I don't appreciate the reconsideration because probably I haven't had a chance to really study it. But I don't feel like I see it differently than I did on Friday, and by that I mean I'm having trouble understanding why something that happened in September is something that they wouldn't have known about before. So if Flow Sports, who filed the lawsuit as the plaintiff with allegations that something was appropriated or whatever, and then finds out something 10 months later, I'm just having trouble with that, Ms. Burgess. So again, sort of.
So let me
Let me complete that thought. That's A. That's what I suggested to you I was having trouble with on Friday. Your argument today is that, well, they've asked questions today that may have opened that door. And I'm not sure that's true, at least in the case of Mr. Soltero, because his questions were, does Flow Sports have any evidence? And not whether or not Mr. Machuco himself knows or doesn't know something, but whether Flow Sports has any evidence. And so I still am struggling a little bit with this notion that at the time of his deposition, he said one thing, and then after you got some additional information, his answer would change. I'm still struggling with that just a little bit. I really am.
Well, first, Judge, the question that was posed to him in his deposition was whether it came off the laptop. And that's the reason that's important. It didn't come off the laptop. It got downloaded from the Google Drive. And this is important because when we originally filed the lawsuit and went for the TRO, we had the laptop. And the laptop said there was, and you'll see there are 69 spreadsheets that were downloaded. Well, it was very difficult with a MacBook to prove those forensics. Then on September 16th, 2020, we got the actual spreadsheets that Saylor has. And then on October 5th, 2020, Saylor testified that yes, he downloaded them from the Google Suite, that he's maintained them, and he continues to access them and has all along. And so, yes, evidence developed. We didn't take his deposition until October 5th, largely because you'll recall that there was about 4 or 5 months of this year where we had no hearings and no activity because of COVID. And so, yes, evidence developed. And once we got those spreadsheets and were able to say, yes, what their forensic examiner originally said is accurate, he admits it. Then that's why we amended our answer and why
Yeah, so let me make sure I understand. At the time of Mr. Machuco's deposition, he did not have any information about the spreadsheets. Since then, you've learned from Mr. Saylor that Mr. Saylor accessed something. And that's what we're fighting about today, basically.
they're the same spreadsheets. But yes, he did testify about the spreadsheets at his Mr. Machuca did testify about the spreadsheets at his deposition.
So it's fair to say that at the time the lawsuit was filed, Flow Sports made an accusation that something that they really didn't have any evidence of at the time, but now have learned that evidence, and that is the reason that they're changing their position, basically. I mean, that's
No, not at all, Judge.
right. With regard to the spreadsheets, I mean, I'm saying just with regard to the spreadsheets, is that where we are?
No, the forensic examiner told us that he had downloaded 69 spreadsheets, and we believed him. And then he said our footprint on this Mac is really hard to directly tie. This is after the temporary injunction. And he said, it's very hard to accurately tie. I'm concerned about this. And he told us that after. When he told us that, we said, okay, we're not going to put that on. And then we get this, it turns out he was right all along. Saylor produced back the spreadsheets and admits that he's been using them. He should have produced them to us in the very first round of discovery. He did not. It took till September 16th for us to get those. And so that we were right all along. Our forensic examiner got concerned that there was a problem, and apparently Macs are the hardest ones to trace. And so there's no question he was right. It's not a random number. It was 69 spreadsheets, the same spreadsheet. It's a matter of proof.
Yeah, okay. And the issue about the laptop was basically, your argument there basically is that they didn't specifically ask him anything other than the laptop. So whether or not he accessed them in some other way can't be held against Mr. Machuca, because they just asked him about the laptop and not whether or not Mr. Saylor accessed it in some other way besides the laptop.
That's right. Yes, Your Honor.
Okay. All right, Mr. Sotero.
Yeah, so Ms. Burgess is not a witness, as Your Honor knows, number one. Number two, this forensic examiner they're talking about, they de-designated and prevented us from getting any discovery on that. In addition, we had to file not only a motion to compel to get an answer initially with Your Honor in February, we again filed a motion to compel basic evidence that was set for September 17th. At that time, we specifically had asked, give us the 69 spreadsheets or whatever you're talking about, give us the 175 screenshots. The day before and the day of the hearing, they produced some stuff. And I'd like to show Your Honor something, if I may share the screen. Counsel for plaintiff represented to us, okay, in our call that, as you see number 2, if we drop the motion to compel, they're no longer claiming that the downloading the 69 spreadsheets was a trade secret, okay? And so we believed that they were pursuing this competition theory perhaps, but it's not a trade secret. In addition to that, the allegation that we didn't produce something in time is incorrect. Mr. Merle was in charge of that, and on February 25, 2020, he produced these very spreadsheets that they're complaining about now, and he produced them in native, and he sent an email saying, if you have a problem, let us know. They didn't get back to us until September, at which time he resent them, and there were another one, which is a spreadsheet that was then snapped back. And so it is incorrect to say that we didn't produce this information. They're trying to rely on something that apparently a forensic examiner did, but then was never made discoverable in this case. So I am shocked and certainly feel sandbagged that they're continuing to pursue this. And I would request that if they have the evidence, this is not the witness. They should get a proper witness who actually knows what the spreadsheets are and can talk about them.
Okay. All right. Well, I'm not going to reconsider. I'm sorry.
There's no way they could be sandbagged. This has been ever since we got them on September 16th. It's been in our petition, in our amended petition. It's been in our answers to discovery. It's been completely part of our case, and it's really unfair to show a discovery dispute email out of context like that.
Did you get the information in native in February?
No, we did not. No, they said they sent it. We couldn't access it. We still couldn't access it in September. So
let me ask a better question. Not whether you accessed it. Did they send you something in native at all in February?
Yes, they sent something, but we could never link to it. And so when we
okay, hold on, wait. Let me just get some clarification on my questions. Yes, they sent you something in February in native, correct?
Yes, Your Honor.
When did you tell them, if you did, when you could not access it?
What happened was
my question isn't about a date, Ms. Burgess. When? If you got it in February, when, if ever, did you tell them it was not in a usable format, or that you couldn't access it or couldn't read it or couldn't understand it or whatever? If you did that, when did you do that?
we didn't know that we couldn't access it until we moved to compel, and they said you already have it.
Well, you've already told me that you got something from them in native in February. So are you telling me that you didn't know that there was a problem with what you got in February until September?
We didn't know we got, I'm sorry, we didn't know we got it.
Well, I don't understand what that means. We didn't know we got it. If they sent it to you, you had it. I don't know what you mean. If we didn't know, what does that mean? You didn't read your email? I don't know what that means.
No, of course we were.
No.
Ms. Galaviz can answer. I'm gonna back up so she can answer. Why don't you answer?
I'm just not, I'm not, I don't understand in terms of the simple question I'm trying to get clarity about here. Here's what I'm asking. If they sent you something in February, their argument is they sent you something in February. I'm trying to figure out if that's true. Did they send you something in February? Ms. Burgess has said that they did. I'm like, okay, well, if they sent it to you in February, then you had access to it. But then the next thing I heard was, well, they sent it to us in February, but we didn't know until September there was a problem with it. And I'm trying to understand if that's accurate or not. Yes, ma'am, you're muted, Ms. Galvez.
But I can answer that. We got an email from them.
Well, I'm sorry, hold on. Ms. Galvez, is that, you're muted.
Why don't you explain?
Can you hear me, Your Honor?
Yes, ma'am.
We got an email from them on February 25th with document production. I'm not going to say I know definitively that the spreadsheets were not in there, but we did not have them. I don't know what happened. We did not have them. And so they sent us another link that had the spreadsheets on September 16th. And we don't know, I don't know if they were always in that folder, if they were not in that folder, but what we downloaded and saved in our system on February 25th, 2020 did not have those native spreadsheets.
How is it possible? Well, let me just clarify. I'm not understanding. If they sent you a universe of documents in an attachment, why can't we just look at it right now and figure out what was in it and what wasn't in it?
It's a box link, Your Honor. It's just a link to a folder that they are maintaining on their system. So I'm not making any accusations at all, but they could have put anything in there or taken out of it at this point, and we don't know.
Wouldn't there be a date when somebody did something to the folder? So couldn't you look to see what you had in February? Okay.
I don't know.
Well, and Judge, I would add that we don't have a scheduling order in the case, and so that evidence didn't get developed between that and COVID. Didn't get developed until we had a hearing, and that's when it all came out.
All right. So here, I am not going to reconsider my ruling. I'm going to stand by my ruling. This witness is not going to be the witness who can tell me whatever happened with these documents, because he doesn't apparently know any more than you all can tell me what you got on February 25th or whatever. So that is a mystery that he won't be able to solve. He should be required to stand by his testimony on the date that his testimony was given at that deposition. I appreciate, however, that after that, there was something else that happened. But there are other witnesses that will be allowed to testify in this trial that can shed some light on that. I don't think Mr. Machuca is that witness. So let's move past him with regard to this issue.
Well, I'm okay with, unless, I think, am I ready to pass? Then I'll pass the witness, Judge.
Mr. Brudico.
No questions.
Mr. Soltero.
No questions, Your Honor.
All right, I have a question,
Can
Mr.
I ask one more question?
I have a question. I'm sorry?
May I ask one question to Mr. Machuca? I lost
Sure.
track in my.
Sure.
Sure. I want to give him an opportunity. Mr. Machuca, was there anything in your declaration to the court that was untrue?
Objection, Your Honor. That calls for a legal conclusion. That's for Your Honor to decide.
Well, he can tell me if he made a mistake. Overruled. You can tell me, you can answer that question.
No.
Well, so when you swore out the declaration, were you telling the truth?
Yes.
And is everything substantially accurate today?
Yes.
Okay, I pass the witness.
Anything else, gentlemen?
No, Your Honor.
I have a question. I think I understand this, but I just want to sort of really get just so that I'm clear, with regard to the information, if I understand correctly, Mr. Saylor interviewed people, he read the newspaper, he went to events, he was working in the world of wrestling commentary, and he kept information that he learned in a spreadsheet. And if I understand correctly, your allegation is, or Flow Sports allegation is, that he took that information that he'd been working on with him, and he used that information to create rankings when he went, after he left your company and went to Rofkin, correct?
Precisely, yes, Your Honor.
All right, but the rankings themselves are public facing. There's no secret there, right? They are what they are, and they change from time to time. Well, that's really two questions. Let me be fair. They are what they are. That is, he takes all that information that he keeps on a spreadsheet, and he creates these rankings, and the rankings themselves show up in this public way, correct? No, but that's not a secret, right?
Correct, Your Honor.
The information that he uses to create the rankings, also not a secret, correct? That is, it's information from who won the match, whose weighs however much they weigh, who uses whatever equipment they use, who put who in whatever kind of hole they put whoever in, right? Like all of that is also not a secret, right?
That's true, Your Honor. It's, yes.
Okay. So it's really the sort of, I guess what I'm trying to understand a little bit about is, and I get the compilation of the data, which is sort of, you know, how he works his magic. I sort of get that, but I'm just trying to understand in terms of information, what, if any, information that he gathers comes from something confidential at Flow Sports, if any?
I guess, Your Honor, you know, all these data points over 8 years, it's not just entering of data and compiling data. There's notes as well.
Right.
The way
I get that. I'm asking, what about those things is not otherwise available? So for example, who won the match is not a secret, it's all public. Who weighs whatever they say they weigh, although I'm told that's not always accurate because they try to, you know, make them taller for basketball and make them hit whatever. But like that information also not proprietary with Flow Sports, right? So my question is, of all these data points, is it the mental process of putting it together and creating the ranking that you believe is proprietary? Or what I'm really trying to understand is, are you taking the position that the data point is confidential and a secret of Flow Sports and proprietary? That's what I'm really trying to understand.
What I'm saying, Your Honor, is that one, not all of the data is public record. There will be match notes about matches and stuff that's not easily accessed. What I'm saying is that compilation, that body of work, we paid him to maintain and compile over 8 years.
Right.
And taking it with you to a competitor is the exact reason why we signed the contract.
No, I understand that. My question is slightly different. I'm really just trying to break this into little bitty pieces because it's easier to digest that way. And my question about this data point issue is fairly simple. Is there any trade secret or proprietary information that you believe is contained within those spreadsheets that's proprietary? The data point themselves, anything in the data?
No, Your Honor.
That's all. That's what I was just trying to get some clarification about. That's helpful.
Yes.
Thank you, sir. I asked a couple questions. Does anybody else have a follow-up to what I asked?
No, Your Honor.
All right, then Ms. Burgess, you may call your next witness.
Judge, if I may, we need to have a hearing before Mr. Saylor goes on the stand concerning Mr. Soltero's Ray tokens issue, and I need to get a witness here for that, and that needs to be offline. It's the AEO issue that he filed a motion on a week or so ago that we discussed at the beginning of the trial. And that
let me stop you there, because I'm guessing that there's going to be much that we can talk to Mr. Saylor about if he's your next witness. Is he your next witness, Ms. Burgess?
Yes.
I'm guessing that there's going to be a fair amount of information that we're going to have to take up before we get to that issue. And so in terms of timing, the next break for the court reporter is going to be about 2:15. So could we maybe have whoever needs to be here then, or thereafter, shortly thereafter? I mean, I don't know how much time you need to get whomever on board.
He is waiting in the wings to sign in. So if you give me 5 minutes notice, I can have him, and I will put him on notice that it'll be plus or minus 2:15. So I'll tell him to be available right after 2.
Okay, it's going to be plus or minus 2:15 because that's when I have to give the court reporter a break.
Okay.
Okay, very good. Mr. Saylor, if you'll unmute your microphone, sir, please. If I remember correctly, you were sworn in on day 1. Let's see, I made a note about all that, and I believe you were sworn in. Do you remember that, sir?
Yes, Your Honor.
All right, then I'll just remind you that you're still under oath, and if you don't mind, if you would just state your name for the record, please.
Willie Saylor.
All right, you may proceed.
I'm going to try to get unsplit screened. So, but oh, right now this isn't going to work, is it? Because my head's cut off. Okay. Mr. Weisbrot, if you could, Ms. Weisbrot, if you could start with F2. And Mr. Saylor, could you please identify this document?
Can I ask that it be blown up or something? Even just a portion of it. Or part of this. That's an email from Martin.
And it's to you?
Yes, ma'am.
And it's February 18th, 2019, correct?
Yes, ma'am.
I move for admission of Exhibit F2.
No objection, Your Honor.
No objection, Your Honor.
Is that Ms. Klinkseisen?
Yes, Your Honor.
Okay, are you going to take this witness? Very good. Thank you. I'm just keeping track. I heard a voice, but I didn't see you. I have you now on the side of my screen. I'll just reorder the boxes. Thank you, ma'am.
Mhm.
Plaintiff's
Okay, so-
exhibit, hang on. Plaintiff's exhibit number 2 is admitted. Okay, go ahead.
Thank you, Mr. Saylor. You probably saw this in the opening statement. It's the one where Martin Floriani is talking about the flywheel, correct?
Yeah, the flywheel.
Okay. And he said that he's going to be, first of all, he says he needs somebody to lead the effort to talk to drive subs, correct?
Yeah.
Objection.
It looks like to me he's
Hang on, Mr. Saylor. I didn't hear the objection, the grounds for the objection.
The document speaks for itself and it mischaracterizes what it says.
All right, perhaps you can rephrase your question a bit, Ms. Burgess, to maybe solve that problem. But
Sure.
clearly the document speaks for itself, but you can ask him about it because it's in evidence. But let's ask him a question without judgment, let's say.
Sure. The first paragraph says that Mr. Floriani hasn't figured out what exclusive content they could provide that would drive subs, right?
I haven't figured out what exclusive content they could provide. That's what he says, yes.
And he needs somebody to lead that effort, correct?
That's what it says.
Okay. And again, later in the second paragraph, he also says he needs someone to lead that effort.
So, Ms. Burgess, it says what it says, but as I said, since it's in evidence, you can ask Mr. Saylor a question about it, but you don't need to ask him to read it to us. So if you want to know something about it, you can certainly ask him, but we don't need him to read it.
Isn't it true, Mr. Saylor, that Martin Floriani was reaching out to you to have you lead the effort on content?
I don't know if that's what he's doing here. I mean, in one sentence, he says he's trying to figure out what exclusive content they could provide. In another sentence, he's saying he would like somebody to be in meetings.
Now, he wanted you to be the flywheel to get the wrestling content going for Rockfin, didn't he?
I don't know. I don't know. I don't know
Yeah,
if I don't know if in this conversation, if I was the flywheel or if he was asking who I thought might be the flywheel. I don't know.
He gives a third point that he needs someone to help him, right?
Yeah, the one thing that's clear, I think, in this is that he's looking for help.
Okay, and you know that just the day before this, he had said, I want this to be you, right?
I think that was like a very vague, like, hey, look, this content creator is successful. You could probably be successful too, or something to that extent. I don't know if it was in any of the roles that he's talking about here.
But this is a multi-page email that's multiple colors, correct? And you can scroll down, it has titles about kind of business planning, correct?
I can't see the whole thing.
Okay, Mr. Weisrod, can you flip through the 3 pages for us?
I don't exactly recall everything that was in this email.
Okay, I think you referred to something being casual, but this is a sort of a formal document, right?
I don't know if it's a formal document. It looks like he asked questions and I gave him feedback, maybe, or I gave my 2 cents, my prerogative.
Right. If we go back to the front, I think that the blue is Mr. Floriani and you're the black asking all these questions. So let's go back one more page. You see, read my responses below in blue, and that's from Mr. Floriani.
I think the concept makes so much sense.
So if you don't mind, it would be helpful for our court reporter if you could just read that to yourself before you answer, because she doesn't know whether you're offering testimony or just sort of reading things to yourself. When you're ready, let us know.
I understand.
Thanks.
What is the question, Mrs. Burgess?
Sure. It says, do you see right in the middle where it says, read my responses below, and it's in blue?
Yeah. Did I write that or did he write that? I'm having a hard time following.
Right. It looks like that's from Mr. Floriani, correct?
So again, Ms. Burgess does not get to testify, Mr. Saylor. So let's start with that. Do you know whose comments are in blue and whose are in black? And if you need a minute to review it, please take a minute to review it. But this would be helpful for us to know who the author of the words might be on any particular page.
Yes, Your Honor. I did the font on the screen that I'm viewing. It's very tiny.
Could we get that blown up a bit, please?
But I believe I understand now. Mr. Floriani's words are in blue, right?
Okay. And here he's telling you he wants to team up with you again, correct?
He said it would be special to team up with you, yes.
Just the day before he had texted you about coming to Rockfin as well, correct?
I don't know.
Let's go to page, the second page. Or actually, sorry, Mr. Weisrod, let's stay there for a moment. On the first page, if you'll pop out the bottom email. This is 9 months before you left, correct?
Yes.
And you're a full-time employee for Flow Sports with a non-compete, correct?
Yes.
All right, and you went and saw a demo and you know that Mr. Floriani is interested in hiring you, correct?
Yeah, yes. I saw a demo. I don't recall what the demo was, just for clarification purposes, but I don't recall the demo. It looks like I love the concept and impressed by the Twitter-like interface, which means I mean, it indicates to me, I don't remember seeing the demo, but it indicates to me that it must have been, he must have shown me the site or something.
Let's go to the next page. One of the very first question that you have is whether Rockfin has a video player, correct?
Yes.
And then, and the second question you ask is whether they would go after events and get into streaming. And would you go ahead, Mr. Weisrat, include the answer? And he tells you that yes, but that Mr. Floriani, that Rockfin would actually be hosting the events and they would get a royalty, correct?
These were the first sort of conversations I'd had with Warren. Obviously, according to this, I don't know much about, I mean, I'm making suggestions that don't make sense to him is what was happening here. If that leads us to do live events, we'll do it. They won't have it on their site in our model. So I didn't have a very firm grasp on what he was getting into.
And I need to object to non-responsive.
I'm sorry. So what was the question?
Wait. I need a second for the judge to rule.
I think he's indicating to you that he needs you to repeat your question because he's not clear about it.
Okay. So the second question is you're asking Mr. Floriani whether Rockfin is going to get into events and go into streaming, right?
Yes.
And in particular, you bring up the National High School Coaches Association, which is in an exclusive relationship with Flow Sports, correct?
Yes.
And you still work for Flow Sports for 9 more months after this, right?
Yes.
And you go on to say that, he goes on to say that, yes, they would do that, but that the events would actually be hosted on Rockfin and they would get a royalty.
He said, we will do what's best for Rockfin. That's what he said.
And that
Yes.
he says NHSCA won't have live events on their site in our model. They would have us hosting and be getting royalties based on the performance and the subscription model, correct?
Right. This is a hypothetical.
But
Right.
that's what happened with, say, Nittany Lions, right? They don't put the live stream on their site. You have to go through Rockfin and then they get a royalty.
Objection foundation.
I don't know. Nittany Lion
Hang on a second. Hang on a second. He's indicated that he does not know the answer to that question. So let's move on to the next question.
Okay, when you watch the Nittany Lions wrestling event, you have to buy Rockfin for that, right?
You have to sign up through a channel. I don't know how you. I mean, and on one hand, you could say you have to subscribe to Nittany Lion Wrestling Club. On another hand, you could say you have to subscribe to any channel on the Rockfin platform. On another hand, you could say you have to sign up for Rockfin. So,
Well, you
all
have to
three would
pay
be
Rockfin.
accurate. Excuse me?
I'm sorry. You have to
Ms.
pay
Burgess?
Rockfin. You have to pay Rockfin, correct?
You have to pay to watch it, yes.
And you have to pay Rockfin.
Your Honor, I'm going to object as vague. I'm not sure what she's asking about.
The question is not vague. He may not know the answer, in which case he can tell us, but the question is not vague at all. Do you have to pay Rockfin to see a Nittany Lions event? That's the question, basically. He may not know, but that's not a confusing question, I don't
You
think.
have to pay $9.99 to Rockfin. I guess I'm getting hung up on how that money is distributed afterwards, which is not the question, so I should just shut up. Yes, you have to pay $9.99 to Rockfin.
Okay, and once you're on Rockfin, once you're a subscriber, you can see all the channels, right?
Yes.
Okay, so Rockfin hosts the event. You don't go to Nittany Lions' personal website to see it. You go to Rockfin to see it.
You go to Nittany Lions Wrestling Club channel on Rockfin.
On Rockfin. Now, let's look at page 2 of this document under headhunting. Mr. Floriani told you there were 81 people in the wrestling community he wanted to reach out to, and that's why he wanted you to come on board, correct?
81, I don't see where 81.
I'm sorry, this is the wrong one. It's I think it's the next one. Yes, it's part 2 of that same section. Sorry. There you go.
Yes. What's
He was telling you he wanted you to take over wrestling, right?
well, he said I can't wait for someone to take over wrestling.
And this is interesting. He said in the last paragraph here, exclusivity. Are you asking something? Okay. In this last section, exclusivity, you asked him whether you could do Flow Sports and Rockfin, and he said under your contract you couldn't do both, right?
Yes.
And you agree that that is true?
Yes.
When we go down to page 3 to the top section, Mr. Floriani did bring Nick V or Nick Veliquette over to Rockfin to head up marketing, didn't he?
Nick was hired there, yes.
And that came for he came from Flow Sports, correct?
He used to work at Flow.
Let's go to the next section, bundles. It's imperative here, is it not, that you get one subscription for all. One Rockfin subscription gets you everything, right?
Objection vague.
It's not clear to me if you're asking if that's what the document is referencing, or I'm just not sure I understand your question.
And I think he already answered it. I'm just saying Mr. Floriani is pointing out to you that you would have one subscription to Rockfin get you all the channels, right?
You know, and he asked me for feedback in these hypotheticals. I'm comparing it. I'm looking at, you know, I don't know a whole lot about what he's doing, and I'm comparing it to Substack, and I'm comparing it to YouTube and Patreon, and I just wanted to get an idea for how it worked.
Objection non-responsive.
I think, Mr. Salo, she's just asking you how you understood the answer from Mr. Floriani in this instance. Do you understand it as she described it or not? That's all she's asking you.
That you get, and I'll add so that it makes sense in the context. I'm asking you, you pay one subscription price and it gets you all of Rockfin. You pay Rockfin and you get all the channels.
Yeah, that's the question I was asking. Patreon, I believe, is like five you pay per content creator. Others are in a bundle. Others are by topic. So he's telling me that this one, it's all in one.
At Flow Wrestling, if you're subscribed to Flow Wrestling, you get all the wrestling content, correct?
If you subscribe to Flow Wrestling, you get all the wrestling content. Yes.
Let's go to 163. Okay, and Mr. Taylor, feel free to zoom through this a little bit so that you can identify these. They're your text with Mr. Floriani.
Oh.
Can you identify this document?
Yeah.
Oh, I'm sorry. This is an agreed exhibit, so I can just go ahead and offer it. I'm probably wasting time by having the identification.
Is 163 on your list of agreed exhibits, counsel?
We have no objection to 163.
Plaintiff's 163 is admitted.
Let's go to page 1.
But we do have an objection to displaying it on the screen because it says confidential.
Okay.
That will, then I need Mr. Saylor. to have
Mr. Saylor needs to have a copy if she's going to be asking him questions about it. Does he have a copy of 163?
Your Honor, I don't know that he does, but I can get him one. Or, you know,
No.
Great. Would you send it to him, please?
yes.
And it's probably, I mean, one of the things is, I don't know what the basis is to call this confidential.
Well, it says confidential on the bottom of the first page that you showed us. I think
I
that's,
understand that, right?
I don't know that has any significance at the moment, but that's what it says. So maybe you could tell counsel what pages you are going to ask him about, and we can find out if those are ones that could be displayed to save time.
Great. It's 1, 3, 4, 6, and 7 at this point.
What?
Well, let's start with 1. Does anybody have any problem with 1 being displayed?
No, Judge.
All
I
right,
don't.
let's start there.
Could I go ahead and get the rest of them okayed, because it's a conversation, so it's not going to make sense out of context.
And Judge, it's going to take me a little time to find the exhibit and send it to him.
I already sent it to him, Carlos.
Thank you.
And we did send them a list of all the exhibits we were going to use in advance.
And Your Honor, I believe it was 97 exhibits that they sent. So it's,
It was
Yeah, I don't-
actually 200. It was 267.
so.
Here's the thing, not important for me to know right now. What's important for me to know right now is if there's anything in exhibit number 163 that cannot be shown on the screen in order to save time to get through these questions for Mr. Saylor. If there is, she's told you what pages she wants to display. Could you repeat those numbers, please?
Certainly, Judge. 1, 3, 4, 6, 7.
Anybody have any objection to those pages of this exhibit being displayed? All right, hearing none. Yes.
What I would say is it's 213. I know you're
Yes,
going to break
no,
it.
but I want to get through this exhibit if that's at all possible. We said
Right.
plus or minus 215, so I'm still within that range. Is there any objection to showing 163 pages 1, 3, 4, 6, or 7? Very good. Let's get through those. Go ahead, Ms. Burgess.
Yes, let's look at the first page. Can you tell us the date, Mr. Saylor?
All I have is a black screen.
Yes, you know what? Well, it's actually down there, but counsel, Judge, we need number 2 as well. My numbers were off on my, so it's 2. So then would it be 2, 4? Okay, I have one that's actually 2.
Anybody have any problem with that page?
No, Your Honor.
Okay, so page 2, please.
So there's no objection to the first and the second page. Go ahead.
Okay, on the second page, here you go. Can you tell what day this is, Mr. Saylor?
It's too small right now.
Okay, I can represent you as the
214.
14th, Valentine's Day.
214-19. Yeah, so you're going to Ben's fight.
Okay, and do you see where it says to the left is, I believe the left is from you, and it says, I'm going to do a bonus code. Do you see that?
Yeah.
Okay, so you said you're talking about your Rockfin channel here on February 16th, 2019, while you still work for Flow Sports, right?
Mm-hmm.
And we
Yeah.
know from the previous exhibit that you can't do, and your previous testimony, that you cannot work for both Flow Sports and Rockfin, right?
Yeah, correct.
And so then Mr. Floriani responds that he wants to warboard it out. And what does that mean?
I don't know what that means.
When you turn to the next page, you were asking whether you could have a salary potential position at Rockfin like you did at Flow Sports, right?
Yes.
And that is what you actually got. You got a W-2, you became a W-2 employee of Rockfin when you left Flow Sports.
Yep. $1,500 a month.
And you also had a channel too, right? So you got paid for subscribers, correct?
Yes.
And at Flow Sports, you also got a base salary and then paid by subscriber, right?
I had a bonus structure the last year and a half, 2 years maybe.
And it was based on per subscriber, right?
It was based per 100 subscribers.
Okay. And let's go to the next page. Which is the one where it says, what do you need to make it a no-brainer? Make a no-brainer one. Hold on. If you go back one page, sorry, I've got my, it's a little out of order here. If you look at the bottom of this page, it said, Mr. Floriani asks you what you need to make this a no-brainer, meaning going to Rockfin, right? This is on the previous page, Mr. Weisfeld.
Objection, speculation.
We get the right reference, so he knows what you're asking him.
There you go. You got it right here.
And what's the question?
Okay, wasn't it that Mr. Floriani was saying, what did you need to make it a no-brainer to go to Rockfin in February of 2019?
Is there a question? I'm sorry.
She's asking you if that's how you understood this question from in the text.
Oh, yes, that's, I assumed that's what he was saying. If I make this a no-brainer.
And your response was you needed security, right?
Yeah.
And so then you followed up by saying, can I be an employee? Correct, on the next page?
What I said was that, you know, the prospects of going out on your own, there's no security there. Who knows if you're going to do good or bad, right? So I was asking if he had positions as opposed to being a content creator, if he had positions.
And then you took one of those positions as head of recruiting, right?
Well, no, I mean, that was a made up position.
Well, that's what the offer letter said, right?
I'm sorry, you cut out, Ms. Burgess.
That's what the offer letter said, was you would be head of recruiting.
I don't recall.
Well,
That whole thing was a formality. I don't recall what the offer letter says. I don't even recall what the title of the job was.
well, and you wanted insurance, correct?
I wanted health insurance. I felt I needed health insurance.
And Rockfin continued to pay your health insurance to just about a month ago, right?
Yes.
And do they do that for any other content provider?
No idea.
And the other thing you wanted was security, which involved your salary, right?
I don't know. I just wanted security. I don't know if it's salary or I don't know. I just didn't want to, I have a job that I've been at with Flow for a decade, and you obviously don't want to plunge into uncertainty,
Now, if we go to the next page, Oh, actually, stay on that same page, sorry. If you look at right below that on the 25th, the next, or the same day later on, Mr. Floriani asked if you wanted to get on the phone, and he thought you were looking to wait and see, correct?
Yes.
Okay. And then the next day, he asks if you want to have a check-in call. I'm sorry, not the next day, on the next page. So that was February. And then on the next page, this is 243, right? Now we're moving forward to April, and it appears that Mr. Floriani still wants you to come work for him at Flow Sports, correct? I mean, at Rockfin.
Yeah, I mean,
And did you meet,
we chatted about it on occasion.
did you meet up with him at that point?
April 19th. I don't know.
If you're seeing, you were seeing a demo back in February of 2019. When did you start talking to Mr. Floriani about coming to work for him?
A demo in February. I don't know. I think then.
Sometime in February, earlier in February?
I think that was the first occasion.
Let's go to 2 pages forward. Well, actually, let's go 1 page forward. There you go, that's it. And he's, Mr. Floriani is telling you that you can make a lot of money in these Ray tokens from subscribers, correct?
He's telling me that some other creator is tracking to a certain degree. I don't know.
Okay, with a particular amount of that currency, right?
Yes.
Okay, and then if you go to the next page, he's continuing to tell you how much you can make in Ray tokens based on particular amounts that other people made, right?
Yes.
Let's go to the next page. Is this the t-shirt that is made about you?
Yes. These things are all so tiny.
Are you aware that these t-shirts are still for sale right now on the internet despite the temporary injunction?
Apparently, I don't know. I've never looked to see if they were still on sale, still on their website for sale. I also was never instructed to follow up and tell anybody to not have them for sale.
Let me just make sure that I've got 3 people frozen on my screen. Is anyone, are you all hearing me?
We hear you. I can hear you just fine. Mr. Saylor appears to be able to hear
Great.
you. Ms. King size and has
Okay, that's great. They're just frozen on our screen, but they can hear us. Okay, great. And then but so you know that you don't know, or you do know that these are still up for sale?
I don't know.
And you did have a licensing agreement with Mr. Boschata for those, correct?
I don't believe I've ever signed anything.
Well, one was exchanged, right?
Your Honor,
I think
I'm going to object to that question as calling for a legal conclusion.
Whether or not a document was exchanged, how does that call for a legal conclusion?
Well, Judge, because
The question was one ever exchanged?
exchanged.
Did they
I'll withdraw
send
the objection.
back and forth? I think is what she's asking him. That don't think that's calls for a legal conclusion, so that objection is overruled. Do you know the answer to her question, Mr. Saylor?
Yes, I believe so. I had a friend, he was the head of this company, Scrap Life, or
That's not the question. The question was whether or not a licensing agreement was exchanged.
I believe he sent me an agreement. I do not believe that I returned it.
And but you knew that it was being, you know that it's been sold online, correct? You have one of the t-shirts.
They sent it to me. The
And
company,
Nick V bought one, you knew that too, right?
yeah, I know a couple people that bought them.
Okay. And if you go back to 245 is the Bates label, Mr. Weisrod, and we're almost finished with this exhibit. So we had February, then we had exchanges in April, and then now it's in May, and Mr. Floriani is still trying to recruit you, correct?
Jack calls for a conclusion to what he's trying to do.
I don't
Calls
know.
for him to speculate about the motivation of another. That objection is sustained.
Mr. Saylor, at this point in May, Mr. Floriani is still talking to you about coming to Rockfin, right?
On occasion, we text occasionally. I don't know if I would, at different points and different times. I mean, I think 2 pages prior to this, there was a text message from Mr. Floriani that said, I don't think you should come to Rockfin right now. Right. So there was varying, there was times when Martin, hey, I think you would enjoy this type of work and you would do well here. And there was other times when he said, no, don't do that. And there was times where I was like, Martin, I ain't never going to Rockfin. I don't know what it is. They pay you in cryptocurrencies. Other times I was like, man, it might be neat to try something new. So we were back and forth between, both of us had reservations. Other times, both of us was probably, on the same page. So, yeah.
But it continued for 9 months, right?
I don't know.
Objection.
It did not continue for 9 months. I remember.
Hold on a minute, Mr. Saylor, there's been an objection, but I didn't hear the grounds. I'm sorry.
Vague.
Sustained.
Let's go to the bottom half of this page, Mr. Weisrod. It meant a lot to you that Martin Floriani was reaching out and inviting you to dinner and inviting you to come work for Rockfin, didn't it?
What? Come to dinner? I don't know. I don't recall being in Austin in July.
Of 2019. And he invited you to dinner and you told him he was your God, correct? Later that night.
Mm-hmm.
And it's true, isn't it, that it meant a lot to you that he wanted you to come to Rockfin?
Yeah, I have a lot of admiration and a lot of respect for Martin. So, when I consider him sort of a mentor and I think he taught me a lot of creativity and innovation. And for somebody that you respect to say, hey, there's this opportunity over here, maybe you're interested. I mean, brings a certain level of satisfaction, right?
Okay, that's all we have on that document right now, Judge. So I know you.
All right, well, let's take our afternoon break while the court reporter's resting up and switching out. I'm going to give everybody a little bit of a comfort break, but if you could be back in about 5 minutes, we'll take up this issue with Ms. Dickey's expert or whomever. So get comfortable, take 5 or 6 minutes to do that, however much you need, and come right back if you would, please.